They sued me for obstruction, not for anything I had done to their road, not for damage, not for interference with any lawful activity, for obstruction. Specifically, the Cedarwood Pines HOA filed a civil complaint in Harmon County Superior Court, alleging that my placement of a locked gate across what they called the community access easement was an unlawful obstruction of a recorded right-of-way, and seeking an injunction to compel removal of the gate. Damages of $31,000, representing alleged inconvenience and rerouting costs to the 73 households of Cedarwood Pines, and attorney fees. The gate they wanted removed was on my land. The road it crossed was on my land. The easement they claimed was recorded was not the easement they thought it was, and the attorney fees they were seeking were about to become a considerably more interesting subject than they had anticipated when they filed. My name is Bernard Cray. I am 63 years old. I spent 28 years as a municipal surveyor for Harmon County before I retired in 2019. I have surveyed more property lines, more recorded easements, more disputed boundary situations, and more cases of people building things on land they did not own than I can count across 28 years of professional practice. I know what a recorded easement says, and what it does not say with the specific precision of someone who has read several thousand of them in the course of actual work rather than in the abstract. When the Cedarwood Pines HOA built a road across my property in 2018 without notifying me, without a construction permit, and on the basis of an easement that authorized pedestrian access for utility maintenance and explicitly prohibited vehicle traffic and permanent construction, I did not file a complaint the day I found it. I surveyed it. I documented it. I researched every instrument in the title chain going back to the original plat. And then I installed a gate, locked it, and waited for the lawsuit I knew was coming. Because when you have spent 28 years reading what property instruments actually say, you develop a specific patience with people who are certain they know what an instrument says without having read it carefully. The lawsuit came on a Thursday morning in April. By the following October, the HOA had paid me $64,000, removed the road at their own expense, restored my property to its pre-construction condition, and their board president had resigned in circumstances I will describe in detail because the circumstances are the part that explains why the board president's attorney filed a separate motion requesting that certain discovery materials be sealed, which the court denied. Comment below where you are watching from. Because this story ends with a lawsuit that produced the opposite of what the HOA intended, a survey that said something different from what the board had told its residents for 4 years, and a retired municipal surveyor who had been waiting for exactly this opportunity since the morning he walked his back fence line and found a gravel road where there had not been one before. My property is 11 acres in the rural portion of Harmon County, purchased in 2004 when I was still working for the county, and wanted land outside the municipal boundary, where I could eventually build a proper workshop and have room to manage a small orchard I had been planning since my children left home. The 11 acres is bounded on the north by a county road, on the east by a residential development called Cedarwood Pines, on the south by a private agricultural parcel, and on the west by a second county road that runs parallel to the first. The eastern boundary, the one shared with Cedarwood Pines, runs approximately 800 feet north to south and had been, when I bought the property, a clean line with mature hardwood timber on my side and the development's perimeter landscaping on theirs. There was an easement on my property that had been granted in 1987 by the previous owner, a man named Gerald Hollister, to the then unnamed development that would become Cedarwood Pines. I knew about the easement before I bought the property because I had done my own title research, as retired municipal surveyors tend to do when purchasing property, and had read every instrument in the chain going back to the original county plat. The easement was specific. It granted a 12-foot wide pedestrian access corridor running north to south along the eastern 20 feet of the Hollister property, now my property, for the purpose of utility maintenance access to the underground electric and telecommunications infrastructure that had been installed along that corridor in 1986. The easement granted pedestrian access only. It specified no vehicle traffic. It specified no permanent construction. It specified that the corridor was to remain in its natural state, except for the installation of utility infrastructure already in place at the time of the easement grant. It further specified that any maintenance activity requiring vehicle access would require separate written permission from the property owner, obtained not less than 30 days in advance of the activity. I had known about this easement for 15 years before anyone at Cedarwood Pines apparently read it carefully. In 2018, Cedarwood Pines undertook a community improvement project. The project, which I learned about entirely through reconstruction after the fact because nobody had contacted me, involved improving access to the development's eastern boundary common area. The common area on the eastern side of Cedarwood Pines had previously been accessible only through the development's interior road system, which required residents to drive through several internal intersections to reach it. The board had decided that a direct access route would be more convenient. The direct access route they selected ran through the utility maintenance corridor on my property. The HOA's board had apparently reviewed the 1987 easement and concluded, incorrectly, that it granted a general access easement across my property that could be developed into a road. The board hired a contractor in the spring of 2018, and a gravel road was constructed across my property over 2 weeks in June. 8 feet wide, crushed limestone base, graded and compacted, running the full 800 feet of my eastern boundary. They put a gate at the county road end and a gate at the Cedarwood Pines common area end. They did not contact me at any point before, during, or after construction. I discovered the road in August of 2018 when I was walking my eastern fence line doing my annual maintenance check. I almost walked past it twice because my brain kept interpreting what I was seeing as something other than what it was, the way you reject information that does not fit your existing model of a situation. Then I stopped and looked at it clearly. A gravel road, 8 feet wide, running the length of my property. I stood there for a while. Then I went home, got my survey equipment and my title file, and went back. I surveyed the road's position relative to the recorded easement boundary. The road was entirely within the easement corridor, within the 12-foot width of the pedestrian access grant. It was also entirely contrary to every condition and restriction in the easement instrument. The easement was for pedestrian access only. The road was built for vehicle traffic. The easement prohibited permanent construction. The road was a permanent construction. The easement required advance written permission for any vehicle access. No permission had been requested or granted. I photographed the road from 17 positions with GPS coordinates on every photograph. I measured the road width at 6 points. I documented the gate hardware and the tire track patterns showing regular vehicle use that had already begun in the weeks since completion. I pulled the construction permit records at the county building office. There were none. The road had been built without a permit. I called a friend at the county road department to ask whether any utility work had been authorized in that corridor recently that might have explained the construction. There had been none. The road had no legitimate purpose under the terms of the easement. It had been built by an HOA that had read a pedestrian utility access easement and decided it meant something it did not say. I went home and began a folder that I labeled Cedarwood East Corridor with the same documentation discipline I had applied to every survey and property dispute in 28 years of municipal work. Then I called a property attorney named Ruth Acaffer, who had practiced in Harmon County for 22 years and who I had worked with professionally on boundary disputes during my county service. I told her what I had found. She asked me to send the title documents and my survey photographs. She called back the next day. "Bernard," she said, "they built a road on your property without a permit, without your permission, in violation of every operative condition in the easement instrument." "I know," I said. "What do you want to do?" I said I wanted to install a gate and I wanted to wait. She said, "Wait for what?" I said, wait for them to file a lawsuit telling me what they think the easement says. Because when they do that, they will have committed their legal theory to the public record, and I will be able to respond to it with everything I have built. She was quiet for a moment. You think they are going to sue you? I think they are going to build a legal theory around that easement that does not hold up, I said. And I think the best place to demonstrate that it does not hold up is in court rather than in correspondence, because correspondence allows revision and adjustment and repositioning. A filed complaint is a committed position. She said, you have done this before. I said, 28 years of property disputes teaches you that people who are certain they are right make different choices in litigation than people who are uncertain. She said, you want to let them be certain long enough to commit. Yes. She said, that is either very patient or very calculated. I said, in property law, those are usually the same thing. I installed the gate in September of 2018. A commercial-grade steel gate, properly hinged to posts I set in concrete on my side of the easement boundary, with a lock keyed to a key I held. The gate did not block the county road. It blocked vehicle access to the gravel road at the point where the road crossed from the county road right-of-way onto my property. Pedestrian access through the gate was possible with a simple latch that I designed to be openable from either side without a key, preserving the pedestrian utility access the easement actually granted, while preventing the vehicle traffic the easement explicitly prohibited. I notified the HOA in writing the same day I installed the gate. The letter was on Ruth's letterhead and cited the specific easement instrument, the specific conditions violated by the road construction, and the specific language prohibiting vehicle traffic and permanent construction. It explained that the pedestrian access the easement granted was preserved. It explained that vehicle access was prohibited by the easement terms and that the gate was installed to enforce those terms. It explained that the road construction had been conducted without a required county permit and without the advance written permission required by the easement for any vehicle access activity. And it invited the HOA to contact Ruth to discuss options for resolving the situation, which included removing the road at their expense, seeking a court determination of the easement terms, or negotiating a new and properly documented access arrangement at a rate reflecting the fair market value of the access they wanted. The board president at that time was a woman named Patricia Saul, who had been in the position for 3 years and who had, according to the board meeting minutes I later obtained, characterized my letter to the board as an aggressive overclaim by a disgruntled neighbor who had a limited understanding of the community's recorded rights. The board voted to refer the matter to their HOA attorney and to continue using the road pending legal resolution. They continued using the road for 4 years. The gate remained locked to vehicle access for 4 years. Residents with pedestrian access still had it through the unlocked latch system I had designed. But the road they had built, the one they were driving on every day to reach the eastern common area, was physically inaccessible to vehicle traffic for 4 years because of my gate. I documented every vehicle approach attempt. My camera system, 3 cameras covering the eastern boundary, recorded every interaction at the gate. There were a substantial number of them. What I did during those 4 years, beyond documenting, was continue building the case. I obtained the full set of board meeting minutes from 2017 through 2022 through a records request under Georgia's Open Records Act, which applies to HOA records in certain circumstances. The minutes documented the board's decision-making process around the road project. They documented that the board had reviewed an easement instrument before approving the project. They did not document that any attorney had reviewed the easement instrument before the project was approved. The board had looked at the 1987 easement themselves and made their own determination that it authorized vehicle access and permanent construction. Neither of those conclusions was supportable by any reasonable reading of the instrument. I obtained the contractor records through a separate public records request related to the permit violation. The county had issued a notice of violation for unpermitted construction in December of 2018, 4 months after my letter. The HOA had paid a fine of $1,200 and applied retroactively for a permit. The permit had been denied because the construction was on property the HOA did not own and did not have a valid easement for vehicle access on. The permit denial was in the county records. It was a formal determination by the county building office that the road did not have valid legal authorization. I had that document. I had been patient for 4 years. Then the lawsuit arrived. The complaint was filed in April 2022. Patricia Saul had left the board president position in 2020 and had been replaced by a man named Dennis Albright, 55, retired from a regional bank, who had apparently made the decision to resolve the easement dispute through litigation on the theory that 4 years of a locked gate was costing the community more in inconvenience than a lawsuit would cost in legal fees. He was wrong about the second part. The complaint alleged that my gate constituted unlawful obstruction of a recorded easement, that the easement granted general access rights across my property that included vehicle access, that my interpretation of the easement was incorrect and self-serving, and that the community had been damaged by 4 years of restricted access to its eastern common area. The damages sought were $31,000 in rerouting and inconvenience costs, plus attorney fees, plus injunctive relief compelling me to remove the gate and refrain from any future obstruction of the easement. Ruth called me the morning she received the served complaint. "Bernard," she said, "they filed." "I know." She said, "They have committed to the theory that the easement grants vehicle access." "Yes." She said, "You have been waiting 4 years for this." "I have been building for 4 years," I said. "There is a difference." She understood the difference. We had 6 months of documented evidence, a permit denial from the county, 4 years of gate interaction footage, the original board meeting minutes showing the decision process, and the 1987 easement instrument itself, which said exactly what I had been saying it said for 4 years. We also had something else that I had found in year 3 of the waiting period, something that the HOA board had apparently not found in 4 years of using the road and litigating its existence, because they had not read the title chain with the attention a retired municipal surveyor brings to a property dispute. The 1987 easement had been granted by Gerald Hollister. But Gerald Hollister's title to the property in 1987 had been subject to a prior restriction that had not been extinguished at the time of the easement grant. The prior restriction, recorded in 1962 as part of the county's original plat approval for the area, stated that the eastern 20 feet of the parcels in that grid section were designated as a utility infrastructure corridor, and that no access easement granted over that corridor could exceed the scope of utility maintenance purposes without a separate county authorization. The 1962 restriction predated the 1987 easement. It ran with the land. It bound every subsequent owner and every subsequent instrument granted by those owners. It meant that even if the 1987 easement had attempted to grant vehicle access and permanent construction rights, it could not have done so validly without the county authorization the 1962 restriction required. No county authorization had ever been sought. No county authorization had ever been granted. The HOA's road was not just unauthorized under the terms of the 1987 easement. It was unauthorized under a 1962 county restriction that predated the development, predated the easement, and predated every decision the HOA had ever made about what the easement meant. I had found the 1962 restriction in year 3 while doing a systematic review of the full plat records for that grid section. It was in a plat book at the county recorder's office that was not easily searchable by parcel number. You had to know it might be there and look for it. 28 years of municipal surveying teaches you to look for things that might be there. Ruth's response to the complaint was 43 pages. It included the full easement instrument with highlighted annotations. It included the 1962 plat restriction with a chain of title analysis demonstrating that it was still operative. It included the county permit denial. It included the board meeting minutes showing the decision process and the absence of legal review before construction. It included 4 years of camera footage on a thumb drive demonstrating continuous vehicle access attempts at a locked gate. It included a professional survey affidavit from a licensed surveyor in private practice, a former colleague of mine, confirming that the road construction was entirely within the utility corridor and entirely inconsistent with the easement's operative terms. And it included a counterclaim. The counterclaim sought $47,000 in damages covering the fair market value of vehicle access to my property for 4 years at the rate the county assessor's office used for access easement valuation, which was a public figure I had obtained from the county's own records. It also sought the cost of restoring my property to its pre-construction condition, which my contractor had estimated at $19,000 for road removal and grading. And it sought attorney fees under the Georgia statute authorizing fee awards when a party brings a claim without substantial justification. The claim that the 1987 easement authorized vehicle access and permanent construction, in the face of the instrument's explicit prohibition of both, was going to be difficult to describe as substantially justified. Dennis Albright's attorney, a man named Craig Foster who had been practicing HOA law in the region for 17 years, called Ruth 2 days after receiving our response. His tone was different from Stuart Bale's tone in the bike path case. This was the tone of someone who had read 43 pages of response, watched whatever portion of 4 years of camera footage his client had shown him, and understood that his client's theory of the case had a problem. Ruth told me afterward that the call lasted 22 minutes and that Craig spent most of it asking questions rather than making positions. He asked about the 1962 restriction. He asked how it had been found. He asked whether it was still operative given subsequent development activity in the area. He asked about the county permit denial and whether there was any appeal process that had been pursued. He was building his own understanding of the full picture while managing a client whose board had committed to a legal theory 4 years ago and had filed a complaint based on it. Ruth answered his questions directly because our answers were all good answers. The 1962 restriction was still operative. It had not been vacated, and there was no mechanism by which subsequent development activity without specific county action could vacate it. The permit denial had not been appealed because the grounds for denial were legally valid, and an appeal would not have succeeded. Craig asked Ruth whether we were open to a settlement conference. Ruth said we were open to discussing resolution on terms that reflected the actual legal situation, which was that the road had been built without authorization, that the easement did not support the HOA's use, and that we had a legitimate counterclaim for 4 years of unauthorized access and cost of restoration. Craig said he would discuss settlement parameters with his client. 2 weeks later, he called back with a proposed settlement figure, $20,000 and a new properly documented easement granting vehicle access at a negotiated rate going forward. Ruth said no. Our counterclaim was $47,000 in access fees alone, plus $19,000 in restoration costs, plus attorney fees. $20,000 did not address the actual situation. He said his client had limited financial resources. Ruth said the limitation on his client's financial resources had been created by his client's decision to build an unauthorized road rather than negotiate an access arrangement in 2018. He said he would go back to the board. The mediation was scheduled for July. A retired Superior Court judge named Harold Mims conducted it. He had the particular efficiency of someone who had seen the full range of property disputes and could identify within the first 30 minutes where a dispute was going. He called the parties into separate rooms after a joint opening and spent the first hour with Dennis Albright and Craig Foster. I do not know everything that was said in that room, but I know the result when Harold Mims came to our room afterward, because his first question was whether we would accept $64,000 in full settlement including restoration at the HOA's expense. He said the HOA's board had done a revised assessment of their legal position and concluded that proceeding to trial created risks they were not prepared to accept. Ruth looked at me. I looked at Harold. I said, $64,000 and they remove the road and restore the property at their own expense, and there is no future easement for vehicle access. Harold said that was the structure being proposed. I said we would accept that structure. The settlement agreement was executed in October. The HOA paid $64,000 from their reserve fund and from their insurance coverage. The road removal and property restoration was contracted to a civil engineering firm and completed in January of the following year. The limestone base was excavated. The graded surface was restored to natural grade. Topsoil was applied and seeded. The restoration cost the HOA $23,000 separate from the settlement payment. Total cost to the Cedarwood Pines HOA for building an unauthorized road on my property, and then suing me over the gate I installed to enforce the terms of their own easement. $87,000 and 4 months of contractor work to undo what they had done. Part 3, 4355. Dennis Albright resigned from the board the week the settlement agreement was signed. His resignation letter cited the desire to allow new leadership to move the community forward following a difficult period. The difficult period was the period during which his board had approved litigation against a retired municipal surveyor over an easement question, received a 43-page response that included a 1962 plat restriction nobody on the board had previously been aware of, and settled a complaint they had filed for $31,000 and a gate removal by paying $64,000 and spending an additional $23,000 removing their own road. 2 other board members who had voted to file the lawsuit resigned the same week. A special election produced 3 new board members. The new board president, a woman named Harriet Vance who had been in Cedarwood Pines for 11 years and had the measured manner of someone who had watched the previous board's decisions with increasing concern, called me the week she was seated. "Mr. Cray," she said, "I want to start by acknowledging that the community caused you a significant disruption and that the way we have handled this situation since 2018 has not reflected well on the board or the community." I said I appreciated that acknowledgement. She said, "I also want to ask a direct question. Why did you wait 4 years rather than pursuing legal action when you first found the road?" I said, "Because the best time to demonstrate that someone's legal theory is wrong is after they have committed to it formally. A board that believed it had a valid easement for vehicle access was always going to build the road back if I had forced them to remove it through informal pressure. The 1962 restriction and the permit denial and the 4 years of camera footage were things I needed them to be in court to use." She was quiet for a moment. She said, "You knew about the 1962 restriction when you installed the gate." I said I had found it in year 3. She said, "You did not mention it in the cease and desist letter Ruth had sent in 2018. No, why not? Because I did not need to show my full hand in the opening letter. The opening letter was accurate. The easement terms were the issue. If they had responded to the opening letter constructively, we would never have needed the 1962 restriction. When they did not respond constructively, I added the restriction to the file and waited for the right context to use it." She said, in retrospect, "If the board had responded to Ruth's 2018 letter by retaining property counsel who read the easement correctly, this entire situation would not have happened." "Yes," she said, "the board that received that letter was confident they were right." I said yes. She said, "Confidence and correctness are different things in property law." I said, "That is a lesson that costs different amounts depending on when you learn it." She said it had cost this community $87,000 and 4 years of a locked gate. I said yes. She asked what the community needed to do to ensure this kind of situation did not recur. I told her, any project affecting the boundary between the development and adjacent properties required a title review by a licensed attorney before board approval, not a board member reading the easement, not the HOA's general counsel giving a verbal opinion. A written opinion from a property attorney who had reviewed the full chain of title, including all restrictions and reservations. She said the board would implement that requirement. It was in the governance policy document by the following month. The Harmon County Building Office, which had issued the permit denial and the notice of violation in 2018, incorporated the case into their training materials for permit reviewers. The specific point incorporated was that a claimed easement for construction activity on private property required review of the full title chain, including pre-existing plat restrictions, before the construction permit could be assessed. 3 neighboring counties adopted similar training guidelines within 2 years. The case was not precedent-setting in the formal legal sense because it settled rather than going to verdict, but it was in the professional record. Ruth had been asked to present on it at a Georgia property law continuing education seminar. I had been asked to contribute to an article for the County Surveyors Association newsletter on the identification of pre-plat restrictions in complex title chains. The 1962 restriction that had been sitting in a plat book at the county recorder's office for 60 years, unnoticed by every subsequent transaction, had ended up in professional education materials because a retired municipal surveyor had found it while systematically reviewing records that most people would not have known to look at. Harriet Vance sent me a card at Christmas the year after the settlement. Handwritten. It said, "The community understands better now what it owns and what it does not. Thank you for the way you handled this, even though it was not easy for any of us." She signed it with her name, and below it wrote, "We fixed the fences." I had noticed that. Their perimeter landscaping along the eastern boundary had been properly maintained since the new board took over. The old decorative rail that had marked their boundary had been replaced with a proper fence that reflected the actual property line as surveyed. It was good fencing, set correctly, maintained properly, respectful of the line it marked. I walked my eastern boundary the following spring as I did every spring. The property line was clear. The utility corridor was in its natural state. The gravel road was gone. The ground where it had been was recovered to the point where you could not tell, except that the grass was slightly newer and slightly more even than the surrounding growth. In another season it would be indistinguishable. I stood at the county road end of the corridor for a few minutes. The morning light was coming across the property, the way it comes in the rural South in April when the hardwoods are leafing out, and the air still has enough cool in it to be comfortable. I could see the cedarwood pines perimeter fence along my eastern boundary, properly maintained, properly positioned on their side of the line. I could see the utility infrastructure that ran along the corridor, the same infrastructure that had been there since 1986, the same infrastructure the 1987 easement had been written to maintain access to. Everything in its correct position, everything on the correct side of the correct line. I had spent 28 years doing that work for the county, making sure things were on the correct side of the correct line. It was not different work when it was my own property. It was the same skill applied to the same problem. You read the instruments. You survey the positions. You document the discrepancies. You wait for the right moment to present what you have found in the context that makes it undeniable. And you are patient with people who are certain they are right, because certainty without accuracy is a gift to the person who takes the time to be accurate. Hit the like button if you believe that reading an instrument carefully before acting on it is not a bureaucratic nicety. It is the entire difference between authority and assumption. Subscribe for more stories about property, documentation, and the specific kind of patience that comes from knowing exactly what the records say. And if you know someone whose property is being accessed or encroached upon by a neighboring development or organization, send them this. Because the most important question you can ask before you respond to any property claim is not what they say the instrument means. It is what the instrument actually says when you read every word. Framed thumbnail text. Built a road on MY land, then sued me. Subtext, lost everything in court.